Well, good afternoon, everybody, and thank you very much for attending this webinar on the NPPF 2023 and local plans. This webinar lasts for an hour. We've got quite a bit to get through, and we will do our best, as it were, to deal with the essential issues concerning housing supply, local plans, Greenbelt, and associated issues which the new NPPF addresses to a greater or lesser extent. And I'm pleased to say with me this afternoon, I have Verity Bell and Wayne Beglin. I hope you can see them on screen. Verity, are you there? Can I see you?
I am indeed. Thank you very much, Paul.
Okay, thank you.
And good afternoon.
Now, I understand that the Q&A function is enabled. And so if you have any questions which we might be able to address towards the end of the webinar, we will make every effort to do so, time allowing. And that the slides and a recording of this webinar will be made available to all of those who requested to watch this. We will make sure that you receive those by email before the end of the week. So let's get underway. The essential reforms, such as they are, can be identified under several headings. But I think it's fair to say, before I go to those by way of introduction, that the expectations of many that the reforms to the NPPF will be quite drastic, particularly in relation to Greenbelt authorities and the need to meet assessed housing needs. Probably many members of those authorities have been disappointed that greater has not been given to the Greenbelt, for reasons which we'll come on to discuss in a moment. So what are the essential areas? Those relating to housing delivery. The government's aim was to improve supply and the delivery of housing by making changes to, for example, the 5-year supply and delivery of housing. Now there's no need for local authorities to demonstrate that if the plan is less than 5 years old and they've identified a 5-year supply at the point of examination, no need to demonstrate a 5-year supply at decision-making stages. And a 4-year supply only need be demonstrated by those local authorities who reached Regulation 18 or 19 stage, have policies which allocate or draft policies which propose allocations to meet those requirements, along with a policies map. And we'll come on to discuss this, but of course there are a great many local authorities who fall within that 4 to 5 year category, where the tilted balance is debated ad nauseum at planning appeals. That will bring an end to that debate in relation to those authorities if they can demonstrate those requirements, at least until the end of 2025. The removal of the 5 and 10% buffers in the assessment of supply. Changes to the requirement to assess housing need. The standard method now being said to be an advisory starting point. Well, what does that mean? New text has been added to paragraph 60 of the NPPF, which Wayne will come on to deal with, which clarifies the overall aim in the context of housing delivery, which should be to meet as much of an area's identified housing need as possible. Well, what does that mean? And of course, paragraph 61 says that if exceptional circumstances can be demonstrated, um, it may be appropriate to use something other than the standard method as calculating the housing requirement. And the question is therefore, well, what constitutes those exceptional circumstances? Are they demographic and population forecast-based circumstances, or are they spatial circumstances, or both? Does it mean, therefore, that local authorities will be able to plan for a lower number of houses? And would local authorities be brave enough actually to set about a plan that does that, at risk that an inspector might find the plan unsound? And alteration to greenbelt boundaries. Now, there's no requirement for local authorities to review their greenbelts when they come to review their plans. But what does that really mean in practice? Does it mean that you don't have to review your greenbelt in order to accommodate housing need? Well, we don't think so. And of course, we'll come on to discuss that as well later on. There are other reforms in the NPPF which deal with extensions, energy efficient buildings, and of course, the quality of agricultural land. So that which is of highest quality seems, as it always has done, to receive the greatest protection. But there is now a requirement to look at lower quality land in advance of that as a way of meeting development needs. So on that basis, and after this short introduction, I'm going to ask Wayne to address the slides and to commence a discussion in relation to those changes. So over to you, Wayne.
Thank you, Paul, and good afternoon, everyone. Pleasure to have you with us. I'm going to go through a number of the main changes that have been made to the NPPF, but as Paul has already indicated, there are a very substantial number of changes, and so we've elected to try and focus our attention on what appears to be those that are most pressing for the audience members who may want to send further questions in, and we've done that by reference to a very helpful list of questions that we'll be coming on to later in the seminar that's already been sent through to us. So if I can ask Will, please, to take us on to the next slide. So the first question that it is worth asking in relation to the NPPF 2023 is what has not substantially changed. And there are a very significant number of matters that have been left in substantially the same form as they were in 2019. I've listed some of them in the left-hand box that will be important both to plan makers and decision takers. And the first relates to the duty to cooperate, which therefore for the time being remains substantially identical to what has been in place for plan making purposes. The exercise that's involved, the essential exercise in preparing and reviewing plans at paragraphs 31 to 33 remains the same, as does, with one notable change that I've set out in the right-hand box, the test for the examination of plans, and that is critical, bearing in mind the other changes that have been made to what is the primary instrument of national policy. And so, of course, one of the tests of soundness is whether or not the emerging local plan is consistent with national policy. And now, in reviewing that question, an inspector can take into account other statements of national planning policy where they are relevant, but the tests are essentially the same. Importantly, in terms of dealing with major applications, whilst there is an emerging local plan process, the process for refusing on the grounds of prematurity is still the same in national guidance. That's paragraphs 48 to 50 now, and it still presents only a very limited basis for refusal of even significant planning applications on that basis. The sections of dealing with conditions, obligations, and general enforcement provision remain the same. as do many other later complete sections of the NPPF, such as those dealing with town centres and so on, which is virtually identical to what we have now. So bearing that in mind, if we can move on to the next slide, as good a place as any to start in this kind of analysis is paragraph 1. And so here there are changes to paragraph 1 of the new version of the NPPF, and what we've endeavoured to do for the sake of clarity, although in general we're discouraged from doing this kind of thing in PowerPoint presentations, what we have done is set out in blue text the changes that have been made, with some underlining to emphasise certain points that appear to us to arise from the new drafting. And so an important expansion to paragraph 1 in 2023, and one sees here, as we see through the document, as we look through it, the emphasis on the provision of housing, and to a certain extent the separation of how the assessment of housing takes place compared to other needs that a local planning authority may have, for example, for employment, land, retail, and so on. And so what we see is the need for a framework within which locally prepared plans can provide for sufficient housing, so housing dealt with there, and then other development in a sustainable manner. Preparing and maintaining up-to-date plans should be seen as a priority in meeting this objective. And that is a key to what has been said by ministers, both prior to and on the adoption of the guidance. And just bearing that point in mind, before we go further on from paragraph 1, of course, at the time that the NPPF was released, there was a written ministerial statement from Mr. Gove. And in that statement, a number of things were said, and I have noted a few of them just by way of observation, because they relate to the particular passages we're going to deal with. The first observation that Mr. Gove made was that it was only through having up-to-date plans that authorities could deliver the benefits that the planning system could provide. The other side of the coin, which again is a theme both of his written ministerial statement and the changes to the NPPF, is the prospect of additional protection from the risk of speculative development for those authorities that have put an up-to-date development plan in place. The overall housing target of 300,000 units additional a year remains. That's important from the ministerial statement. But the ministerial statement also refers to seeking to clarify what it describes as a local lock on any changes to greenbelt boundaries. And we'll see what the actual text of the NPPF as revised says about that, and whether or not it really amounts to a local lock. Because under the same ministerial statement, Mr. Gove went on to say, it is clear there is generally no requirement on local authorities to review or alter greenbelt boundaries if this would be the only way to meet housing needs. So that's the way he framed the point in that statement. But against the backdrop of what he was explaining, he said there was no excuse for local authorities to not rapidly adopt ambitious plans. So the ideas are rapidity, and for plans to continue to be ambitious, aspirational plans. In relation to the standard method, he said something in the written ministerial statement about that as well. He referred again to it being an advisory starting point, but then carried on to refer to departure potentially being available where a local authority considers the number unachievable. Now, if that's the threshold that is seeking to be applied, unachievable is clearly a very high test. But that was one circumstance in which he indicated that exceptional circumstances, which is the test the NPPF does provide, might fall to be applied. He observed generally that pausing plan making is not good policy, and we know from interventionist steps the government has increasingly been taking in relation to the local planning authorities, that idea is being followed through more assertively than had previously happened. His ministerial statement also mentions the need to provide equivalence between oversupply and undersupply of housing. So that is a measure which is finding its way more explicitly into government guidance. And in a nod to what we might call the Marvel generation, he said, with sharper power, authority and flexibility, however, comes sharper accountability. So those were some of the main messages of the written ministerial statement. And with that, we'll move on to the next slide and look at some of the more detailed changes that were made. Footnote 7, now footnote 8, dealing with the presumption in favour of development, the tilted balance. And we can see key changes being made there for when the tilted balance will be applicable under 2023, where the local planning authority cannot demonstrate a 5-year supply or a 4-year supply, if applicable, as set out in paragraph 226, and we'll look at the text of that later, of deliverable housing sites with a buffer, again set out in paragraph 77, and does not benefit from the provisions of paragraph 76. So we'll look at what paragraph 76 says, and then the other basis upon which the tilted balance can continue to apply in the circumstances we're concerned with, where the housing delivery test indicates that the delivery of housing was below 75% of the housing requirement over the last 3 years. That isn't a substantial change from the text before, it's just a rewording. So next slide, please. And we see there something that Verity is going to come on to deal with in more detail later. Important changes in relation to neighbourhood plan protection. And so I just sketched them out for the time being. People will have noted them, and the prospect of neighbourhood plans potentially having a greater role in the future in terms of providing certainty for an extended period of time over the plan making process. But as I say, Verity will come back to that in more detail. So we can move on to the next slide. And dealing with the meeting of need. And there's an important change in language here, which again is thematic of the way that the NPPF has been changed. One can see in the 2019 version the need for there to be a framework for addressing housing needs and other priorities that are listed there. And then in 2023, on the one hand, what may be a subtle change, but it's significant, bearing in mind that there's a recognised difference in meaning between addressing and meeting needs. We see now a framework for meeting housing needs and addressing other economic, social and environmental priorities. So there's been a deliberate shift there towards an imperative to meet those housing needs. Next slide, please. Now, again, just to note for those authorities, and there may be an increasing number dealing with joint arrangements or even new settlements within their own administrative boundaries, but there is a change in the way the guidance anticipates that new settlements will be approached, perhaps bearing in mind the unfortunate level of failure there have been in inspectors accepting new settlements coming forward under the 2019 guidance. And so there a nod to needing to look to a much wider vision, but not necessarily a longer planned timescale, so that those kinds of policies can be clearly articulated and brought forward in a way that inspectors consider to be sound. Next slide. The main changes, the Greenbelt, perhaps the change that individuals were most eagerly awaiting to see what would happen, especially in relation to the consultation. But now, having taken the temperature across the board, both on the developer side and on the local authority side, one wonders whether or not the changes are of the kind of significance that was being anticipated. And so in order to break this analysis down, what we've done is put in some numbering as to 4 of the things that required consideration, both in 2019 and in 2023. First of all, in paragraph 136, now paragraph 145. And one sees that the changes are perhaps twofold. Firstly, at number 1, where before the guidance was that Greenbelt boundaries should only be altered where exceptional circumstances and so on. Now it is made perhaps more explicit that there is no requirement for Greenbelt boundaries to be reviewed or changed. But as Mr. Gove tells us, that was always the spirit, if not the word, of government policy in that respect. So that's the first element of that. language. It then refers to authorities being able to choose to review and alter greenbelt boundaries, but bearing in mind the need to comply with national policy as a whole. As Paul indicated earlier, that there is a real question as to the extent to which this will allow a significant change in approach for those authorities heavily constrained by greenbelts, unless they wish to see forms of development come forward in a far more intense fashion on other land where development will otherwise fall to be made. So matter two, the test of exceptional circumstances. So that is still the trigger for a local planning authority considering whether or not there may be a choice to be made about reviewing and altering greenbelt boundaries. And it still has to be a consideration of exceptional circumstances on whether or not they are fully evidenced and justified. So that test remains the same. And of course, if the change is to be made, then it happens through the plan making process. So looking at all of those changes, we do wonder whether or not there is in fact a substantive difference to the plan making process that authorities where this issue has been a vexed issue is really going to be altered. Next slide. So dealing with section 5 of the NPPF, which is concerned with delivering a sufficient supply of homes. Some things to note about paragraphs 60 and 61. The obligation, as Paul foreshadowed earlier, the overall aim should be to meet as much of an area's identified housing need as possible. And if those words mean what they say, then plainly, in order for plans to be found sound, local planning authorities are going to have to take extensive steps in order to try to identify sufficient land to meet the need that arises. And then paragraph 61, we come back to the other main point of controversy through the consultation of the NPPF, the reference to the standard method and its function in all of this. And there we see the reference in the new text to the outcome being an advisory starting point for establishing a housing requirement, C67. When you look at paragraph 67, the interesting thing about paragraph 67 is that it only contains an upwards ratchet. There are no examples in paragraph 67 for what might be sufficient to establish exceptional circumstances to reduce the advisory starting point. But here we do find in the next sentence of paragraph 61 the prospect of there being exceptional circumstances, including, so it's not meant to be an exhaustive test, but including relating to particular demographic characteristics of an area. And that's footnote 25 of the NPPF. And when you look at footnote 25, what you'll see is that it gives what truly could be thought to be exceptional circumstances of an area separate from other areas and unconnected by even a land bridge. And so if that's the kind of example the government has in mind as being sufficient to constitute exceptional circumstances, perhaps it gives an indication of what a local planning authority will need to show in order to satisfy an inspector that an alternative approach, which is plainly contemplated by the guidance, it can be adopted. Even in that case, we see that the alternative approach, and this is going back to the old guidance, should also reflect current and future demographic trends and market signals. And the rest of the guidance is as remains from 2019. So if we move on to the next slide, we can see paragraph 76 that I referred to. Local planning authorities are not required to demonstrate 5 years worth of housing land supply for development management purposes in certain circumstances. And this is regarded, when one reads commentary across the piece, as perhaps being the single most significant change to the NPPF and the one that may persuade local planning authorities of the additional benefits that can be obtained by taking their plan making processes forward. If an adopted plan is less than 5 years old and that adopted plan identifies at least 5 years worth of specific deliverable sites at the time the examination concludes. So that's important, not at the point of adoption or any earlier point of the plan making process, but as at the conclusion of the examination. Then it will not be necessary to identify, for development management purposes, that 5 years worth of housing land supply, which has proven both in terms of administrative and logistics very difficult for local housing authorities from time to time, but also, as Paul indicated, it's been quite often the major battle in relation to whether or not the tilted balance should be applied. And then in paragraph 77, the ability to depart from 5 years housing land supply to 4 years housing land supply, where paragraph 226 is met. And so if we move on to the next slide, and what we can see in 226 is that this policy applies to authorities who are getting on with essentially the plan making process. And the important takeaway from this provision is that it applies both to Regulation 18 and Regulation 19, but only in circumstances where the plan includes both policies mapped and proposed allocations towards meeting housing needs. So again, no obligation there, in fact, for housing need to be met in total in order to take the benefit of paragraph 226, but there has to be that minimum of a policies map and a level of proposed allocations which are designed to go towards meeting that housing need. And in those circumstances, for 2 years from December 2023, there will be that additional protection in place for authorities, which may be important because all of us have experience of development management inquiries where it has been the difference between 4.2 or 4.5 and 5.5 years that has made the difference to inspectors. So next slide, please. Next, turning to a different topic, the effective use of land, and perhaps covering these areas more swiftly because that they really haven't changed as much or in as significant a fashion as the earlier slides that we've been looking at. But one sees in paragraph 129, where the new text is in blue, forgive me, the continuing theme to meet as much of the need as possible. And we see in text that hasn't been changed, the continuing use of minimum density standards for town centres and those that are supported by good levels of public transport, and the requirement potentially for significant uplifts unless there are strong reasons why that shouldn't be so. And so when one looks at applying the guidance as a whole and what has changed in relation to green belts, this other central plank of the guidance needs to be borne firmly in mind for plan making processes. Next slide, please. So paragraph 130, we can see that there is the ability to potentially depart from the significant uplifts, but only on the application of a test, which is a very strong test, that the resulting built form will be wholly out of character with the existing area. Now, they will be planning judgments to be formed, but obviously the threshold that's been set by national policy is a high one in that respect. And it also goes on to show how such a concern about development being wholly out of character would need to be evidenced, and it will need to be part of the design code that goes through the adopted development plan and therefore through the examination process. Next slide, please. And then just a little bit more on the design codes and the need for, well, first of all, the obligation to prepare those documents now within a plan-led process, and also the function of the design guides and codes and what they will do. But that's something that can be debated on another day. So next slide, please. Finishing off on the design guides and codes, more detailed guidance here, and again, making it clear that the way that these guides and codes are to come forward is in a relatively formal setting, either as part of the plan itself or supplementary planning documents. And then once they are there, based on effective community engagement, they will be taken into account, and they need in themselves take into account the guidance contained in the National Design Guide and National Model Design Code. There we go. If we move forward, that's fine on that slide, to the panel questions. That's it from me for the time being. I think Paul is going to take us through the first few questions, and then it'll be Verity, and then a bit more from me. Thank you, Paul.
Thank you, Wayne, very much indeed. That was very helpful. I'm going to, what we've done in essence is take into account questions which have been posed by many people who are watching this, and we've put them under various categories. And what we're trying to do now is try and answer those questions in the context of the presentation which you've just had from Wayne. And in doing so, I'm going to invite Wayne and Verity to participate in this as well, because they have much to impart in relation to these questions. So could we have the next slide, please? Okay, what are the key implications for changes to plan making and Regulation 18 for draft plans? Well, this assumes we're moving ahead of an issues and options stage to another Regulation 18 stage, where the plan is being set more in concrete, where you have draft policies up for consultation, and where spatial decisions have been made, albeit subject to further consultation. The key implications for plan making in the context of the changes to the NPPF. I'll come on to deal with green belt authorities in a moment. But overall, and if we restrict this issue to meeting housing need, clearly there is a need on this process now to understand exactly what their housing requirement is going to be, and whether or not reliance is going to be made on the standard method, and whether there are exceptional circumstances which would justify a departure from that. And one has to ask the question whether or not those exceptional circumstances in terms of departing from the standard method relate to methodology, i.e. the assessment of need on the one hand, or alternatively, a basis for reducing the requirement which would have been assessed through the standard method because of particular spatial requirements or other limitations which prevent that number being met. And my view is that it could be either of those things, but in a large number of cases, it may well be considered that the standard method simply produces the wrong figure, having regard to population change and population predictions and the demographics of an area. And I know of several local authorities now who are having great difficulty in understanding, first of all, whether or not the standard method is an appropriate prediction and therefore basis upon which to plan for housing, or whether it's necessary to introduce an alternative methodology which takes into account specific empirical demographic account of the area in terms of what the likely housing requirement is going to be by reference to those more local characteristics. The other thing, apart from that, is the need to make sure, in accordance with the new provisions of the NPPF, that appropriate optimization has taken place in relation to the use of urban land for development. And it might well be that, having regard to this change of emphasis, and it is a slight change of emphasis, local authorities will need to go back and review the extent to which they are making the most efficient use of urban sites and PDL land. So far as Greenbelt authorities are concerned, I do not believe, others may not share this view, but I do not believe that the new NPPF actually provides a basis for reducing the housing requirement. I don't believe that to be the case, and I certainly don't believe inspectors will be taking that view. And it's very interesting, having regard to the ministerial interventions in yesterday's debate, and I might just take the opportunity to read these, that they are still giving the impression that that kind of flexibility would exist. So apparently, referring to paragraph 12 of the NPPF, the Minister for Housing, Lee Rowley, was quick to emphasise that the government has been consistently clear that the standard method for calculating housing land supply is a starting point for local authorities in assessing what to plan for, and that it does not set a mandatory target. He encouraged councils to consider whether the exceptional circumstances referred to in paragraph 61, those relating to particular demographic characteristics of an area, exist, saying he would expect more cases for exceptional circumstances to be accepted by the planning inspectorate, although that would also be for the inspectorate to determine on a case-by-case basis. And the Conservative MP, Dame Maria Miller, expressed concern that if local planning authorities rely on exceptional circumstances, they will be subject to legal challenge. In response, the Minister reiterated the expectation that local planning authorities take the NPPF into account and the update and the need for LPAs to put forward their arguments for alternative approaches in good faith, as if they would do otherwise. But I think that's a message to Greenbelt authorities, not to use that as an issue, as a means of not meeting its needed requirement. So, Wayne, I don't know, do you have anything you would like to add to that?
Just a couple of points, echoing what Paul's already said. I mean, in terms of key implications, certain authorities, and perhaps most obviously those that are either Greenbelt authorities or those that are considering new settlements, will need to revise their strategic approaches, potentially based on the new guidance that we've just been going through, but against the expectation that seems to be clearly there that housing need should be met. And as Paul indicates, if authorities choose to have a greater urban first focus, then in terms of densification, that may well require them to do more than they otherwise might choose to do. And it seems to me it will be important for local planning authorities going forward to continue to test against their constraints, not just whether or not they can meet the standard method, but at least to contemplate whether or not there is room to do more, just so that they can show that their plan making has been sensitivity tested in that way. But also bearing in mind that the tests of soundness are, as we've indicated, very largely unchanged. So again, in terms of what is justified, in order to have a justified position, the authority needs an appropriate strategy, not the best strategy, but one that an inspector can find sound as being an appropriate strategy. So those were my observations on some of the key implications.
Thank you very much. Verity, I don't know if you have anything to add to that.
Nothing further from me.
Okay, thank you very much. Well, the next slide, please. Okay, where the policy environment is uncertain, how should local planning authorities approach the initial stages of a new local plan? Well, first of all, you have to bear in mind that the tests of soundness, as Wayne has said, still apply. And so everything you do has to be measured by reference to that test. And the duty to cooperate guidance has not changed either, although it will change in due course. And of course, some issues in relation to, for example, new settlements will continue to raise significant strategic issues. In my view, the duty to cooperate, when it's replaced with further guidance requiring statements of common ground to be prepared, is going to introduce, in my view, a need for local authorities to work more closely together, particularly where there are cross-boundary implications, and where there are other features which are shared between them. So, for example, in and out migration, the reliance upon neighbouring authorities for the provision of employment opportunities, and where they share, for example, a green belt, and the administrative boundary is really an artificial boundary when one comes to consider the spatial implications of planning for growth. There is a growing tendency now for those types of authorities who are so affected to work collaboratively by producing joint plans. And I think that is going to be a growing approach, not least because it can be then demonstrated that a more sub-regional approach to meeting housing and employment needs is being taken, and therefore a greater rationality might be applied to the way in which, for example, greenbelt releases should be secured. There needs to be also a flexibility in approach and sensitivity test elements of provision. So that's my answer to that. Wayne, do you have anything you would want to add to that?
There's just one point which goes back to the continuing application of the test of soundness. Now, the new legislation, as and when it comes fully into force, plainly envisages a slightly lighter touch environment in terms of the production of evidence. But it's worth bearing in mind for those plans that are coming forward in the meantime that the same test of soundness will be being applied. And so as matters stand, local authorities will need to bring forward the same level of detailed evidence as they are or have become used to doing within the context of submitting local plans.
Thank you very much. Could we have the, sorry, Verity, do you have anything to add?
No, I think Wayne's covered what I was going to say. So
That's great. Thank you very much indeed. So let's move on then to the next slide. Will changes lead to more local plan consultation call for sites in 2024 compared with 2023? The answer is clearly yes. A lot of local authorities have put their local plans on hold, some of those anticipating some profound changes to the NPPF, which might have altered their approach, for example, to green belt releases. And as a result of this, there is now no reason for local authorities to hold back. The strategic changes will mean land is still required, of course, for development, and changes in strategy to be pursued will require evidence or sift for available land. So there will be more local plan consultation and more calls for sites in order to meet needs. And there will be a particular emphasis, I think, on, as I said before, revisiting urban areas as a means of optimizing their contribution to meeting both housing and employment needs. Many existing local plans have built-in review mechanisms. Some plans were found sound on the basis that an early review would be put in place as a means of identifying further land for housing where there was a shortfall in the overall planned allocations over the 10 to 15-year period. So again, those authorities are now going to be charged with considering their evidence base afresh and looking at the way they proceed on the basis of a reworked evidence base, taking into account the new requirements of the NPPF. And that evidence base for all local authorities going through the plan-making process, as we know, is a time-consuming, very expensive and complicated business. Okay, Wayne, do you have anything to add to that?
No, nothing else on that one, Paul. I agree. I think there's going to be a lot more activity this year.
So I'm going to pass over to Verity now. Verity, on the next slide, you're going to deal with neighbourhood plan making in this context. So over to you.
Yes, Will, if you could just move through, I think the slides have got slightly out of order. If we could go through to slide 25, please. Many thanks. So, mindful of time, I thought I would speak briefly about the changed role of neighbourhood plans brought about by the December 2023 update. And indeed, as Wayne said, the biggest change to this is in relation to paragraph 14 of the NPPF, which, as I'm sure most of you will be aware, concerns the presumption in favour of sustainable development where housing is concerned, falling within the scope of paragraph 11D. That is where there are no relevant development plan policies. All the policies which are the most important for determining an application are out of date. Now, one exception to this presumption of the grant of permission is where the adverse impact of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in the NPPF taken as a whole. Now, paragraph 14 goes on to specify the circumstances where the adverse impact of allowing development of that conflicts with the neighbourhood plan is likely to meet that very significant threshold of significantly and demonstrably outweighing the benefits. Prior to the NPPF update in December, neighbourhood plans had to meet 4 criteria to avoid the presumption in favour of sustainable development in paragraph 11D. And the most significant, arguably, of those criteria was that the neighbourhood plan had to have become part of the development plan 2 years or less before the date on which the relevant decision was being made. Now, the key problem with this requirement in practice is the length of time and resources that were required to put together a neighbourhood plan, often vastly exceeded the 2-year period of its currency. And in the latest NPPF update in December, the big change is that that period is extended to 5 years or less, rather than 2 years or less. And it's clear to me, at least, that the policy intention there is to extend the protection afforded by having a neighbourhood plan from speculative development to slightly older neighbourhood plans rather than those just within the 2-year period. Prior to December, other requirements to benefit from paragraph 14 included that the local planning authority had at least a 3-year supply of deliverable housing sites, and that the local planning authority's housing delivery was at least 45% of that required over the previous 3 years. Now, those 2 other requirements are gone in the December update, so they no longer apply in order for the neighbourhood plan to displace that presumption. In my view, the upshot of this is that there's going to be increased significance of neighbourhood plans given the widened potential to disrupt and displace the presumption in favour of sustainable housing development where paragraph 11D would otherwise apply. It significantly reduces opportunities for speculative housing development where a neighbourhood plan is less than 5 years old. Of course, it's important to caveat that with the point that the 14D would remain subject to a further requirement, that is, that the neighbourhood plan contain policies and allocations to meet its identified housing requirements. So having a neighbourhood plan that is less than 5 years old, it isn't a carte blanche, as it were. And that's determined, so whether it meets the identified housing requirement is determined by reference to paragraph 67 and 68, which specify the housing requirement figures that Wayne referred to. So that's what I wanted to say about that. I don't know whether I want to open the floor to Paul and Wayne, whether there's any further comments on that particular issue.
Not from me, Verity, thank you. Wayne, I think we need to move on now. So could we have the next slide? We need to go back in sequence if they're out of sequence. So over to you, Wayne, on these.
Thanks, Paul. First of all, recent changes to the NPPF regarding the 5-year housing land supply and 3-year housing delivery test. Now, we looked at those. In particular in relation to paragraphs 76 and 77. And in addressing one of the questions that's been raised during the course of the discussion today, a question was asked about whether or not the 4-year provision is applicable in circumstances where an adopted plan is more than 5 years old. And the answer to that is yes, the local planning authority can still take advantage of the provisions of paragraph 77, which are additional to those of 76. So 76 provides for a position where if the adopted plan is less than 5 years old and that plan makes adequate provision for 5 years of specific deliverable sites at the time of the examination concludes, then there is simply no requirement to update annually the 5-year housing land supply. Paragraph 77 gives additional protection in relation to those situations where paragraph 226 applies. And we looked at paragraph 226, and it's the provision for those local planning authorities that are making progress towards adoption of a local plan. And so they're given that further window of 2 years for that to take place. And in relation to the 3-year housing delivery test, that still has its role to play, both in relation to paragraph 11, but in the more limited way that the guidance now provides for, and also in paragraph 77 as well, where there is still provision at the end of that paragraph that where there's been a significant under-delivery of housing over the previous 3 years, then the supply of specific deliverable sites is additionally required to include the buffer of 20%, because the other buffers of 5 and 10% have been removed from this version of the guidance. So that's the essence of the differences and the additional protections that authorities now have where they are moving forward with the plan-led process. So can we move on to the next slide? So that 4-year supply rule, does it provide an incentive to submit? I think we would suggest that it does. It's a powerful incentive for the reasons that we were discussing earlier. It is very often the difference in the tilted balance being engaged or not being engaged. And the obligation is not significantly more onerous than it would be for a local planning authority that was bringing forward its planning process under a review clause within an existing local plan, or indeed to comply with the regulatory requirement to consider reviewing a plan every 5 years in any event. And so that has very real potential implications for the application of the tilted balance. In a significant number of cases, I think there was some research released that indicated that even as matters stand, without other local planning authorities taking their plans forward, about 40% of local planning authorities would potentially stand to benefit from the changes that have been made. And in relation to out-of-date policies, of course, it's always worth remembering that even when policies are regarded as being out of date by the NPPF, the development plan remains the starting point, still open to inspectors to consider what weight they think it is right to attribute to those policies in those circumstances. And before we move on to the next slide, I'd just ask whether Paul or Verity had anything they wanted to add on either of the last two slides.
No, simply to re-emphasize that, an inspector will consider whether or not the basket of policies which are essential for making the decision are out of date. That will apply irrespective, of course, of the housing supply issue.
So if we move on to the next slide, and we've got a specific question that came up during our earlier request for feedback. Does the new paragraph 76 that we were looking at preclude, there we go, does paragraph 76 preclude the adoption of a stepped housing requirement approach given 76B? So just pausing for a second and looking at what 76 and 76B are dealing with. 76 is, as we were just seeing, the removal of the requirement that would otherwise apply to identify and update 5-year housing land supply. 76B requires, as one of the criteria, that the adopted plan identified at least a 5-year supply of specific deliverable sites at the time the examination concluded. But there is no further prescriptive guidance as to how that 5-year supply is to be identified. So therefore, there is no preclusion in the guidance as it stands at the moment to adopting a stepped housing requirement if an inspector is persuaded that is otherwise a sound approach in the circumstances, whether because there are new settlements coming forward and so the trajectory is weighted in a way that provides for later provision within a plan period, or for other reasons. So there's no preclusion in that respect. I think that's the view that we take about that. But if Paul or Verity wanted to chip in with any additional observations.
No, that's agreed.
So shall we go on to the next slide? Thank you. And then back to, therefore, two questions really relating to the advisory starting point. And we've drawn attention to the tension that exists between the final version of the NPPF, some of the consultation documentation, and indeed the written ministerial statements that have been provided since. And I referred to one of them earlier, but there have been other ministerial statements as well in relation to, example, a number of authorities who were directed to take certain steps in relation to bringing their local plan processes forward. And again, this point about the advisory starting point was addressed by Mr. Gove in a way that isn't entirely consistent with what's been said elsewhere. And that just goes to indicate but perhaps a level of flexibility about that approach. But I would go back to the words in paragraph 61 and to recall that there will need to be exceptional circumstances. So that will be the touchstone that inspectors use. We're given one specific example of how that might be addressed. That plainly doesn't preclude other circumstances, but there has to be a very real query about whether or not any of the constraints per se that a local planning authority is subject to would be factored in at that stage to an exceptional circumstances case, or whether they might come later in the analysis about what it is possible for the local planning authority to provide. And so I think what we can say at the moment is that there's no indication in how inspectors are proposing to approach this that would indicate that there's a significant difference from the approach that was previously being taken under the 2019 guidance, where the substance of a lot of what was contained in the text is the same. Again, just in case there are other further observations, I'll open the floor on that one before we move on. We may be going back to, I suspect, the Greenbelt questions quite shortly.
I have nothing more on this. Thank you.
So, well, if we can, then I think in the slides, being slightly out of order, what we may have missed out on are slides 23 and 24, dealing with panel questions relating to the green belt. And so I think we're back to Paul on these.
Thank you very much. What I'm going to do is, because we're now at the end of our time, what I'm going to do is use this really as a basis for washing up and bringing the seminar to an end. But the question is, what are the changes to the treatment of the green belt in the new NPPF? Well, we've been through those. I think what the question's probably really getting at is whether or not the treatment of green belts in the context of new plans as they come forward, whether it ought to change in light of the housing and other development requirements of local authorities, having regard to what it is the evidence base establishes is needed. And other than the greater emphasis on making sure that there is optimization of urban land for these purposes. I do think that there is going to be a huge amount of tension, both in relation to Greenbelt authorities and others, and some perhaps misunderstanding by members when it comes to considering the standard method and its applicability to setting housing targets within their administrative areas. And it's going to require very, very substantial and very robust evidence, in my view, to justify a departure from the standard method. And I predict that inspectors are going to interrogate any attempt to avoid the standard method or to adopt an alternative method very, very vigorously. And on that note, I think we're going to have to bring the seminar to an end. And I would like very much to thank both Verity and Wayne for their contributions. And I expect that if you have any residuary questions that need to be asked, that if you want to ask them, put them through chambers, I'm sure we'd be very happy to see if we can respond to at least some of them. So thank you all very, very much for attending. And all I can say is good luck.